There we go. All right. So good morning. I'm Parole Officer Tricello, and I'm here as an examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Leonard Singleton and meet number 376969. Today is Wednesday, July 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Leonard Singleton, 376969.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Singleton.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has responsibility to prove the allegations by preponderance of evidence. That is, a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Singleton, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
Thank you. So I'm going to go over the procedure for today's hearing. So first I'm going to read you your rights. Then we're going to review the parole violation charges up to state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
All right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney. Counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we'll now review the charge that the state, your parole officer, is bringing against you, and the information underlying that charge. So charge number one, the condition of obedience to the law. The charging officer reported that on 4/7/26, Hartford police officers responded to early alerting Head Start in response to a panic alarm. During the investigation, HPD officers were able to review surveillance footage from the early alerting center. While reviewing the footage, HPD officers observed you and the victim engaged in what appeared to be, a verbal disagreement. Officers observed you approach the victim face to face, causing the baby carrier to fall between your bodies. Officers then observed you abruptly raise your arm and strike the victim on the right side of the face. The force of the strike caused the victim's head to turn and her upper body to shift. Additionally, the baby carrier that the victim was holding dropped to the ground. After the physical altercation, you were observed returning to your vehicle and you knocked some unknown items from the hood of your car before leaving the scene. Based on the information and statements obtained during the course of the officer's investigation, an arrest warrant was requested and issued. You have been charged with Connecticut General Statute 53-21, risk of injury to a minor, 53A-181, breach of peace in the second degree. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the parole notice, Exhibit B, the parolee rights, Exhibit C, the parole violation report, Exhibit D, the special parole conditions, Exhibit E, the Hartford PD warrant, Exhibit F, the judicial branch pending case details, and Exhibit G, the remand. The state did also file an addendum to the parole violation report on June 2nd, 2026, that states that on May 29, 26, Mr. Singleton appeared in Hartford court under docket ending in 033S and was found guilty of the breach of peace, second degree, and sentenced to 60 days of jail time. The charge for the risk of injury to a child was nullied. So counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes, I did.
All right, and I did receive 2 exhibits from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for a program statement, and Exhibit 2, a support letter from Gabrielle Mitchell. Counsel, do you need time to send any other documents?
I do not know.
Don't have any witnesses. So at this time, it's the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Thank you. With regard to the one charge here in this violation, as indicated, Mr. Singleton, he did plead guilty. He was under the Alford doctrine to the misdemeanor breach of peace charge. He did receive a 60-day sentence. That sentence has expired at this point in time. He's been locked up for more than 60 days. He did contest some of the allegations here, but he did elect to resolve it under the Alford doctrine, given the practical purposes of the parole remand, and so we can get a hearing. I would note the felony charge was not pursued by the state. I would also note the letter, which was attached as an exhibit from the victim in this case, which does demonstrate that she's very supportive of Mr. Singleton and doesn't have any safety concerns. If there is a finding, I would like to hear further with regard to the sanction. Thank you.
Thank you. All right, Mr. Singleton, so I'm gonna announce my findings. So on charge number 1, the condition of obedience to the law, I am finding that you violated that condition based on your conviction of the breach of peace second when you received a 60-day jail sentence. In addition, the evidence in support of that charge is states exhibits C, D, E, and F. So it does conclude the fact-finding portion of this hearing. Before I make the recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel, would you like to make a statement?
Yes, thank you. So Mr. Singleton, he's 33 years old. He was born and raised in Connecticut with his family. He does have family in the state. His sister lives in Hartford. His mother resides out of state right now, but he does have a close relationship with her as well. His children reside in Connecticut, and Mr. Singleton, he's an active father and stepfather, and he is looking forward to the opportunity to reunite his family, friends, and his children when he is released from incarceration. He is hoping to be sponsored by the mother of his children, who did provide a letter of support. I understand she was the other party, and she was the victim in this case, but both of them are hoping they'll be able to continue to reside together and care for their children and their family. I would note the court elected not to impose any type of standing protective order after the case was resolved that would impede any contact between them. So from a legal perspective, through the courts, he's allowed to have contact with her. He's allowed to reside with her. She wasn't seeking a no contact order, and the court did not impose any type of no contact order. If parole does not agree to this, and Mr. Singleton would need to be placed in a halfway house, and he would be seeking placement in the Hartford area as a backup option, but he is hoping to be able to be reunited with his family. So when Mr. Singleton is released, one of his first priorities will be looking for work. He's open to multiple employment opportunities. He's hoping to get a job in a warehouse if he can. He's done that type of work in the past. He also has his flagger certification, and he recently had been working as a flagger, and he's certainly open to continuing that if that opportunity is available to him. Once he gets employed, he's going to be looking to complete his GED. He's been working on that for some time, and it's something he does strive to do, and he wants to get that done. He's looking into enrolling in trade school. Ultimately, he would like the opportunity to work in either plumbing or HVAC. So he does have plans and aspirations going forward. He just needs to move on here, get started with whatever's available, and then go from there. So he was last released from incarceration back in February of 2024. So he had been under supervision for over 2 years at the time of the remand. And it appears he was doing well with parole during those 2 years. The PBR doesn't list any misconducts during that 2-year period of supervision. Mr. Singleton has indicated he engaged in all the treatment that was required by parole. He didn't provide any positive urinalysis test to his parole officer. And he certainly intends to continue with his compliance and work with parole when he's released. I think he's demonstrated an ability and to work with parole positively, and he certainly wants to continue that. He's been complying with corrections since his remand. He had a job in the kitchen, and he hasn't picked up any tickets since he's been remanded either. So Mr. Singleton's parole officer was recommending a sanction of 6 months and a referral of domestic violence counseling. I would ask you to consider releasing Mr. Singleton at the next available date. He's been remanded for approximately 3 months now, and as I indicated, the sentence which was imposed by the court is over. I also think it's relevant that the more significant felony charge was not pursued by the state. I think the victim supported Mr. Singleton. It's also very significant when considering a possible sanction. She has no safety concerns, and she had very positive things to say about Mr. Singleton. It seems like he really is a good support for her and help for her family and his family as well. Mr. Singleton, he wants to get back to work to support his family. I know they've been struggling financially with him in jail. And as I indicated, he's going to continue working with parole for the remainder of this period of special parole. Mr. Singleton, is there anything you'd like to say at this time?
No.
Thank you.
Thank you. I'm just gonna take a moment, then I'll announce my recommendation. So I have listened to the testimony today. I reviewed all of the evidence that's been submitted by both sides. I do want to note on the record, Mr. Singleton, this is your second violation on special parole, and both have been criminal violations. Both have been domestic violence in nature, and both have been with your children's mother. And that is super concerning to me because they're different children's mothers also, correct? Two different victims. I do see that you were out for a while in between, and with no noted misconduct. However, Parole Community Services, as counsel stated, did recommend the 6-month sanction. So with that, I'm going to recommend that your parole be revoked and that you serve that approximate 6-month period of confinement as a sanction, and that's with the re-parole date of October 23rd, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendants Ricky Williams, Samuel Miller, and Alana Rivera, no contact with victim LR, MC, AC, and OR, a general no contact with SS, NF, and GM without your parole officer's permission, and halfway house placement. I will note that you would like to live with Miss Mitchell. However, I am recommending the no contact without parole officer's permission. So it's going to be up to Parole and Community Services about your housing. It'll be at their discretion what they want to do, but no, if they don't, once you do get out, you cannot have contact with her without going through them first. Make sure you have the conversation with them before you start contacting her and having communication. So what happens next, Mr. Singleton, is that my recommendation is going to go to the board on July 30th. On that date, the board can do 3 things. They can lessen that recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address any questions and concerns before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
No, ma'am.
If you're all set, this concludes the revocation hearing for Leonard Singleton, inmate number 376969. You'll get the decision from them in writing about a week or so after that July 30th. Okay.
Okay.
This does conclude the hearing. Good luck to you, Mr. Singleton.
Thank you. Have a good day.
Thank you. Good morning.
He's on his way down. He'll be here in like 2 or 3 minutes.
Okay, perfect. Thank you.
No problem. Right? No, it's the, it looks like that's the wildfires in Canada.
Again?
Yeah, that's why it's like that.
Oh.
It's well, it's funny.
Oh, the last year?
Yeah, last year, the same thing.
Oh, so that's what.
Yeah, I watched one of those. And I watched the weather from Minnesota. So yes, be hazy is just so that the wildfires and don't let us reach. I watched some video. A guy like a golf swing, you like this, and take your arm, you put it on your elbow. If you like this, you can like get it like your arms like facing the target.
Yeah.
You get it, and also. Yeah, oh, good. It's just it's like it's a little.
Not straight.
Yeah, it's straight. Most really the time it's still rough.
What's the name?
Abraham.
Abraham? No.
I'm gonna hate.
Yeah, you're from the big village, like. Are you from Metro?
Oh, yeah, you're right. Take a seat right here.
Good morning, Mr. Abraham. How are you?
Morning, I'm good. How you doing?
Good. So it is 9:28. We cannot get started till exactly 9:30. So in 2 minutes, we'll get going, okay?
All right, sounds good.
Okay, we're gonna get started. So good morning. I'm Parole Officer Trisella. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Anthony Abraham, inmate number 449668. Today is Wednesday, July 15th, 2026, and this is a hearing being conducted via video at the Board of Pardons and Parole Central Office inside Bowlesby Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Anthony Esteban Abraham, 449668.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Abraham.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence. And that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Abraham, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I swear.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charge that the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights at this hearing, and I'm going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charge that the state your parole officer is bringing against you and the information underlying that charge. So charge number one, the condition is obedience to the law. The charging officer reported that on 3/31/2026, Waterbury Police conducted a motor vehicle stop in which you were the rear passenger in the vehicle and were not wearing a seatbelt. When police asked you for identification, you provided a fake name, Jonathan Cruz, before you eventually admitted your true identity. You subsequently admitted that you were actively smoking marijuana in the vehicle when it was in operation just prior to the traffic stop. As a result of your actions, you were arrested for interfering with an officer, 53A-167A, and use of cannabis in a motor vehicle, 53A-213BA. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the parole violation report, Exhibit B, the notice of parole violation, Exhibit C, the remand to custody order, Exhibit D, the assigned parole conditions, Exhibit E, the Waterbury Police report, and Exhibit F, decision information summary. In addition, they did submit an addendum to the parole violation report on May 7th that states that on May 6th that you appeared in court under docket ending in 687S and pled guilty to interfering with an officer, and you were sentenced to unconditional discharge. The use of the cannabis in a motor vehicle charge was nollied. So counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
And I did receive an exhibit from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to see any other documents?
I do not know.
All right, and do not have any witnesses. So now it is the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Thank you. Again, there's only one charge here on the PVR. Mr. Abraham, he did plead guilty in court to the misdemeanor interfering charge. He did receive an unconditional discharge. There's no allegations of any physical resistance on the part of Mr. Abraham. He did not flee. He did not physically resist the police in any way. He was a passenger in a motor vehicle. He did not give the police the correct name initially when questioned. Upon further questioning, he pretty quickly admitted to his real name. It doesn't appear to me that his actions significantly impeded the police in any manner, as the correct name was given fairly quickly here. That's the entire extent of this violation. Otherwise, he was compliant with all of his parole conditions. If there is a finding, I'd like to be heard further with regard to sanction. Thank you.
Thank you. I'll just take a moment, then I'll announce my findings. Mr. Abraham's on charge number one, the condition of obedience to the law and finding that you violated it based on that conviction of the interfering with an officer when you received the unconditional discharge in May, on May 6th. In addition, the evidence in support of the charge exceeds exhibits A, D, and E. So it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So counsel?
Thank you. Mr. Abraham, he's only 22 years old. He was born and raised with his family here in Connecticut. And when he's released, he's hoping to be sponsored by his father and stepmother who reside in Meriden. He does have family in the state who he has a very good relationship with and do provide him with a lot of support, including his father, his mother, and his brothers who live in New Britain. He's a young man. These convictions he was on parole for were his only criminal convictions. Unfortunately, now he does have this additional misdemeanor for this interfering incident. I think it should be noted, however, that all of his convictions are misdemeanor in nature. He doesn't have any felonies on his record. None of them appear to involve any violence or threats of violence. The underlying case perhaps involved recklessness, but he certainly wasn't threatening anyone, and nobody was hurt, and it doesn't look like he was intending to hurt anybody in that incident or in this incident here. I think it's unfortunate that he needed to plead guilty to this interfering charge. I think most officers don't charge interfering, given that he immediately admitted he had given the wrong name and quickly provided the correct information. If he wasn't on parole, I think he may have had other options available to him in court, and he might have been able to work this out in some other manner without having to have this misdemeanor conviction on his record. In the future, when he does complete this period of parole, he is looking forward to the point where he might be able to apply for a pardon down the road or utilize the Clean Slate Act to try to get these misdemeanors off of his record. Mr. Abraham, he was released to parole back in May of 2025. So he's been on parole for about 10 months at the time here he was remanded. According to PBR, back in September and October, he had 2 incidents where the GPS battery died. But other than that, there's no noted misconduct on the PBR, and this is his first parole violation. He generally looks like he's been compliant with parole during his 10 months. He attended all the counseling and treatment required of him. He didn't give any positive drug tests. Other than those 2 noted issues with the GPS, it looks like he'd been complying with any type of curfews or GPS supervision during that period of time. Since parole supervision started, Mr. Abraham has been working on obtaining his GED. He had in the past been working as a machine operator. He's also worked various moving positions. He has been trying to line up employment for when he is released. He tells me he does have a potential home healthcare position available to him, and he's looking into possible warehouse positions as a backup plan. But he has been trying to prepare for what happens when he gets out, and he's looking forward to get back to work as soon as possible. He has been cooperative during the remand. He hasn't picked up any tickets during this remand or during any of these periods in jail. He's not had many tickets at all, it looks like. He's involved in his community. He regularly volunteers for his local church. I think he's been doing well with parole, and I think he has demonstrated a willingness to cooperate with the supervision. The PBR did recommend a sanction of at least 60 days or 50% of any new court-imposed sentence. So there was no sentence imposed here than the UCD. There's no time that he was given in court. So that period of time has already passed. I do understand Mr. Abraham, he doesn't have a lot of time left on his parole supervision, but I would still recommend that he be released for the next available date. I think he's a young man who, unfortunately, he has made some mistakes here, and he's working on getting through the consequences of those mistakes. But as I indicated, he has never engaged in any violence. He's working on getting his GED, started a career, and trying to move past these mistakes he's made. Given the nature of this particular violation, I think the 4 months spent in jail is more than sufficient as a sanction. I would ask him to be released as soon as possible. Mr. Abraham, is there anything you'd like to add this time?
Yes, there is. I just wanted to let it be known that what I did was a mistake, and it wasn't something I meant to do on purpose. It was out of, me just being scared and me not wanting to come back. And I just felt a lot of guilt, and that's what made me ended up telling him my real name and all my real information. I was just scared. I knew I wasn't supposed to be around the police, And yeah, I just did it out of me being scared and nervous, and I regret it, and I learned from it, and I know better now for sure. Thank you guys.
Thank you, Mr. Abraham.
Thank you. Just take a moment, then I'll announce my recommendation.
Parents in the mental health group role. Good, parents in mental health group role.
Just want to first do the defendants. All right, so Mr. Abraham, I have listened to the testimony today on everything council stated. I reviewed all of the documents submitted. With that, I am going to recommend that your parole be revoked and that you serve an approximate 4-month period of confinement as a sanction, and that's with a re-parole date of July 30th, 2026. I'm going to recommend the following conditions: no contact with co-defendants Stephen Sarbo, Drayvon Robinson. Were these other individuals also arrested, Mr. Spears and Mr. King?
That was
Mr. Spears was arrested.
Mr. Spears only was arrested?
Mr.
Mr.
King,
Spears. Mr. Spears was just arrested for the interfering.
Okay, because otherwise it was just, I was trying to reread it, so they were pulling you over for no plates, no like.
he wasn't driving, he was passing.
Well,
The vehicle was pulled over for.
or just for plates, right?
Yeah. There was a tint in a front marker plate. It was like,
I guess I'm not gonna do it, and if the board wants to, they can. Because Mr. Spears gave it on me as well, correct?
Yes.
Yeah. Alright, I'm just gonna add them. So no contact with co-defendants Stephen Sorbo, Drayvon Robinson, Christopher Spears, and Asim King. And then I'm gonna put, I'm gonna do a halfway house condition just in case, just because if you're gonna be released and the board adopts my recommendation, it's for that day, and I don't know if Parole and Community Services can coordinate to get you, like, to confirm your sponsor and verify the housing. So just in case, I'm gonna do halfway house placement, but I'm gonna note that you wanna go back to your dad's house in Waterbury. And let them, and I'll put the information in for your father. That way they have it now ahead of time. Hopefully they can coordinate it before your release. So what does happen next, Mr. Abraham, is that my recommendation is gonna go to the board on that day, July 30th. So the only two things that can happen is they adopt it, and walk out of the door that day. You're on discretionary.
yeah, discretionary.
Ideally, you'll walk out of the door that day. However, sometimes that doesn't happen. So that's gonna be the day that I'm recommending, July 30th. And if the board adopts it, that'll be your new voted to parole date. The only other thing that can happen is that if the board would want to see anything longer, a longer period of confinement, they'll ask you to come back for another hearing to address any questions and concerns that they have before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
So July 30th, do I hear anything before that? I'll hear something before the 30th.
No, the July 30th is the board review. That's when they decide whether to adopt it, but you may not get out that same day. Since you're on
Okay.
discretionary, it's an on or after. It might be sometime after that, but that's the date that's being recommended.
Okay.
All right,
Right.
so that does include the revocation hearing for Anthony Abraham, inmate number 4496668. All right, good luck to you, Mr. Abraham.
All right. Thank you guys. Have a great day.
Thank you.
That's it.
Good morning, Officer McHugh. Just checking out you're with us.
Hi, good morning.
Perfect. Good morning. Good morning, Robinson, how are you?
Good, how are you? I just called for them again, so they should be down any minute.
Okay.
You're seeing Kenyon and Pacheco?
Yes, please.
Okay.
Thank you.
No problem.
I'm stepping off for 1 second and I will let you know when I come back in like 2 minutes.
Okay, thanks.
Morning.
Ooh, good morning, how are you today?
I'm doing good. Trying to stay healthy.
Okay, that's a good goal for the day. I like that one. You're Mr. Kenyon, correct?
Yes.
All right, so we're gonna get started in a moment as soon as their charging officer is back with us. She just had to step away for a moment and then we'll get started, okay?
Yes, ma'am.
I actually have to step out. We have something going on in the office. No, you're fine. Good morning, Mr. Kenyon. I will follow up with the revocation after it ends, okay?
Mm-hmm.
Okay, so just to confirm, Officer McHugh, you're gonna not be here for either of them, correct?
Correct.
Okay, all right, thank you.
Thank you.
Thanks. All right, then, Mr. Kenyon, we're gonna get started, okay?
Yes, ma'am.
So good morning, I'm Parole Officer Trisella, and I'm the hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Gary Kenyon, and inmate number is 209557. Today is Wednesday, July 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Gary Kenyon, 209557.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones on behalf of Mr. Kenyon.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oaths. Mr. Kenyon, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Excuse me?
Did you receive the written notice of the charges of violation?
Yes.
Okay, great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, we'll now review the charges that the state, your parole officers bring against you, and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 3/11/2026, a file 5 warrant for a wanted person was entered into the database from the Department of Emergency Services and Public Protection. The warrant was for Connecticut General Statute 53A-124, shoplifting, conspiracy to commit larceny third via Canton PD. You were detained and taken into custody on 4/2/2026 when parole was notified of this active warrant. As you are in violation of your stipulated condition number 2, I will obey all laws. In charge number 2, the condition of drugs, the charging officer reported that on 1/21/2026, you reported to the Hartford District Office and provided an oral specimen for toxicology testing. This tested positive for cocaine. On 4/2/2026, you reported to the Hartford District Office and provided a urine specimen for toxicology testing, and it tested positive for THC and cocaine. The following evidence was submitted by the state. It's going and has been marked for identification purposes as Exhibit A, the conditions of parole, Exhibit B, the notice of parole violation, Exhibit C, the parole violation report, Exhibit D, the remand to actual custody, Exhibit E, the Canton PD incident report, Exhibit F, the State of Connecticut Judicial Branch pending case detail, Exhibit G, the offender misconduct report, and Exhibit H, the case disposition. I do have a note that I did not receive exhibit F though, so that will not be admitted as evidence for this hearing's purposes. In addition, the state did file an addendum to the parole violation report, and they submitted that on June 5th, 2026. That reads that on June 4th, 2026, under docket, Mr. Kenyon was sentenced under docket ending in 862S out of Torrington Court for the conspiracy to commit larceny third, and was sentenced to 5 months of incarceration. Counsel, can you just clarify for me? So there were other charges. No, that was the only charge, correct? Just the conspiracy to larceny third? I'm sorry.
That was the only charge.
That was the only.
Yes.
So to confirm, counsel, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Great. I did receive an exhibit from the defense. I have exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
No.
We do not have any witnesses. So at this time, it is the defense's opportunity to present evidence and to speak up to any of the evidence submitted. So counsel?
Yes, thank you. In regards to charge 1, obedience to the law, the agenda is stated accurately. The only thing I would add is that my client did enter into that plea agreement under the Alford Doctrine. I believe his end of sentence date on that 5-month sentence is September 21st of 26, if that's not accurate. But
As of today, it is September 18th.
okay, thank you. Yeah. And then in regards to charge 2 under drugs, I'd only ask for a no finding as it pertains to the testing positive for THC. Nothing further as to the charges.
Thank you. Just take a moment. So on charge number 1, Mr. Kenyon, I am finding you violated the condition of obedience to the law based on that conviction of the conspiracy to commit larceny third when you received the 5-month jail sentence. In addition, the evidence in support of that case is states exhibits A, C, and E. I am making a no finding for the charge number 2 in totality, as the state failed to submit sufficient evidence to support the charge, and therefore the elements were not met. So it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what often I'll recommend. So counsel?
Yes, thank you. My client's 54 years of age. He's single. He has no children. He receives his primary support in the community by way of his mother as well as his sister. He provides assistance to his mother, who is 84 years of age, while he is in the community. He's a high school graduate of Bloomfield High School. He attended the Technical Career Institute. He earned his license in HVAC services. He also holds certifications in carpentry, building maintenance, and serve safe. He was in the community, having first been released to special parole December 12th of 24. So I believe during this period of supervision, he was in the community for approximately 16 months. He first utilized and successfully completed the Connection Halfway House program in Middletown, transitioned to his mother's residence in Bloomfield. He reports receiving medication management services from Charter Oak Health Center in Bloomfield. In addition, he does have a history of program success, having successfully completed the App Foundation during a past supervision while on parole. By way of employment, he reports that he was applying for disability for both mental health as well as medical purposes. He's been within the Department of Corrections now for a little over 3 months. He reports being medication compliant, attends AA and NA meetings twice weekly, reports he attends religious services twice a week as well. In addition, he is reportedly on the wait list for a tierman job. His future plans for parole reinstatement include re-sponsoring to his mother's residence in Bloomfield, Connecticut, and that information is contained within Defense Exhibit 1. Second to that, if he had to, he's asking for a halfway house in the Hartford area. If for some reason his sponsor was not approved. He's amenable to all treatment recommendations, and specifically would like a caseworker assigned to him through CCAR services. By way of employment, he's going to follow up on his application for disability. He is amenable to working a part-time job. He'd like to utilize Connecticut Works for assistance in securing employment. That programming is located in Hartford. He does have aspirations to return to school for drug and alcohol counseling. We would be asking that he be re-paroled in line with his 5-month court sentence. I would just note that his parole officer did make a recommendation of 6 months. That recommendation was made prior to him disposing of his court case. We would be asking again that he just be re-paroled in line with that court sentence. And as we already stated, it's due to expire on September 18th of 26. Thank you.
Thank you.
Mr. Kenyon, do you have anything that you want to add?
Thank you very much for understanding me. And I'm just that 54-year-old. I'm trying to take care of my body because my kidneys were not in the best. So I do a lot of medical treatments in the streets. And both my knees, I can't walk. So I'm trying to have operation on both my knees and trying to go back to school as soon as possible to be a drug and alcohol counselor.
Thank you, Mr. Kenyon. I'll just take a moment, then I'm going to announce my recommendation. Okay, so I've listened to the testimony at today's hearing, and I've reviewed all the evidence presented. With that, Mr. Kenyon, I am going to recommend that your parole be revoked and that you serve an approximate get my dates right. Second. An approximate 6-month period of confinement as a sanction, and that's with the re-parole date of October 2nd, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, a general no contact with MR, mental health evaluation and treatment as deemed necessary, and no operation of a motor vehicle without parole officer's permission. I will put the information about your mother's house as your sponsor for Parole and Community Services to work on that. So what happens next, Mr. Kenyon, is that my recommendation is going to go to the board on July 30th. On that date, the board can do 3 things. They can lower my recommendation if they choose to do so. So any date between July 30th and October 2nd. They can adopt the recommendation if they choose to do so. And then if for any reason they would want to see a period of confinement longer than what I have recommended, they'll ask you to come back for another hearing to address any questions and concerns they have before something longer is imposed. So it does conclude today's hearing. Do you have any questions?
Thank you very much and God bless.
All right, so this does conclude the revocation hearing for Gary Kenyon, inmate number 209557. Good luck to you, Mr. Kenyon.
Good luck,
Thank
Gary.
you.
If you have any questions, feel free to reach out to me, okay?
I'll give you a call.
Okay.
Thank you.
Yeah. Yeah.
Good morning, Mr. Pacheco Rodriguez.
Good morning.
We're going to get started, okay?
Okay.
All All right, so good morning. I am Parole Officer Tristello, and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Pacheco Rodriguez, inmate number 372435. Today is Wednesday, July 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Michael Pacheco Rodriguez, 372435.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones on behalf of Mr. Pacheco Rodriguez.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Pacheco Rodriguez, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the full truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Great. So we are now going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charge that the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Not really. We'll just swing it.
Okay.
I'm
Well,
sorry.
I'm going to
Okay.
assume that your attorney went over this with
Yes,
you. Okay.
Yes, okay, all
I shouldn't
right.
assume, but I'm pretty sure she did. So, okay.
Okay,
So we are going to go over your rights for today's hearing. The first is you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
yes,
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
yes.
We will now review the charge that the state your parole officer is bringing against you and the information underlying that charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 4/26/2026 at approximately 9:14 p.m., Bloomfield PD was dispatched to your residence in response to a disturbance call. The call was disconnected, and it was later reported that was due to you knocking the phone out of the hand of victim 1. It was reported that you and victim 2 were physically fighting in the front yard. It was further reported that you were drinking and then punched victim 2 in the face. It was reported you chased the victim when they tried to get away. During this incident, it was also reported that when victim 1 tried to intervene, you pushed them. Subsequently, you were arrested by Bloomfield PD on the following charges: Connecticut General Statute 53A-61, assault, 61A, assault third, victim elderly or other, 53A-183B, interfering with an emergency call, 53A-61, assault third degree, and 53A-181, breach of peace second. On docket number H14H-CR26-0777073-S, and given a next court date of 4/27/26. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody; Exhibit B, the conditions of parole; Exhibit C, the notice of parole violation; Exhibit D, the parole violation report; Exhibit E, the state of Connecticut Judicial Branch pending case detail; and Exhibit F, the Bloomfield PD incident report. In addition, the state did file an addendum to the parole violation report on June 5th. That states that on June 4th, 2026, Mr. Pacheco received a nollied verdict on all 4 above charges. The assault third elderly, interfering, assault 3, and breach of peace on docket ending in 073-X. It should be noted that the original issued protective order on this case was also terminated. Supporting documentation has been uploaded into case notes. So counsel, to confirm, you and your client did receive the notice of parole violation for all the other documents identified for today?
Yes.
Just want to check, did I miss documents? Did we get updated documents from PCS? Locked out of case notes.
Are you looking for a copy of
Well,
the?
she wrote supporting documents updated. Did we do? There's still not, if I printed them. I just want to see what they were. Sorry, 1 second, Mr.
Yeah, that's okay.
I just don't know if she meant she added documents and
She might have added this, those definitions and all.
that, you got that from us, you think?
No, I believe it's
Oh.
her,
Oh, okay.
but I don't know if that's.
See. That's exhibits, that's. Maybe it was that. Yeah, it is those two documents, counsel. So I'm just gonna identify those as exhibit G. Those are exhibit G. They're, what are they, dispositions, case dispositions? Do you want to see this attachment, or are you good if I admit that as G?
No, that's fine.
Okay, so it is just the one that you showed me,
Yes.
showing that the case was disposed of and the nominees, okay. Okay, so everybody did receive those, so those are gonna be identified as G. So counsel, just to confirm one more time, you did receive all of, the notice of parole violation, report, and all the other documents identified for today?
Yes.
I did receive exhibits from the defense. So I have exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, the letter of support from Hector Pacheco. Exhibit 3, the Hector Pacheco's CT driver's license, and exhibit 4, Hector Pacheco's disabled veteran identification. Counsel, do you need time to submit any other documents?
No.
Or we do not have any witnesses. So at this time is the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Yes, thank you. In regards to charge 1, obedience to the law, the addendum is stated accurately. I just note by way of background, in regards to those charges, my client was held in custody for approximately 6 weeks prior to disposing of that case. His brother and his father both went to court on his behalf, indicating that they did not wish those charges to be pursued against him. And based on that, the state did enter into a valet. It was a situation where my client, his significant other had just given birth to their first child in March, and the family was having a party to celebrate that. He and his brother got into an argument, and obviously that argument escalated to the point where his father just intervened to try to break it up. This is a very tight-knit family. I believe his 2 sisters were present, his father, his mother, both of his parents reside at the same residence. And it's an unfortunate incident that took place, but it's not a situation that is something that a recurring theme. It was out of the ordinary for this incident to have taken place. I believe the court took that into consideration. And again, both individuals went to court on behalf of my client. Those are my comments as to the charge.
Thank you. Let's take a moment and I'll announce my findings. Okay, so Mr. Pacheco Rodriguez, I have separated and identified charge 1, the obedience to the law, into separate parts, each part identified with an offenses charge. And I'm going to make a partial finding to the charge. So I'm making a no finding for the offense of the assault third victim, elderly or other, as the state failed to submit sufficient evidence in support of that charge to meet the preponderance standard. For the offenses of interfering with an emergency call, assault third, and breach of peace second, although court did nolly them, it doesn't negate that the behavior occurred. So I am going to make a finding based on the evidence presented in state's exhibits B, D, E, and F. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what I will recommend. So counsel,
Yes, thank you. My client is 33 years of age, single, though he has a significant other. He does have one child, a newborn that was born on March 27th of 26. His primary support in the community is his mother, his father, his two sisters, his younger brother, as well as his significant other, who also resides with his parents and their child. He's a high school graduate of Bloomfield High School. He earned his CDL from New England Tractor Trailer Training School. He was first released to parole supervision, having gone to a halfway house on December 15th of 2023. He successfully completed Bishop House in Waterbury. Beginning March 19th of 24, he then transitioned to his cousin's residence located in East Hartford, where he remained for approximately 4 months before sponsoring to his father's residence in Bloomfield, again, where both his parents reside. He remained at that residence up until the time that he was remanded. He was in the community then under supervision for 28 months. This is his first violation of parole. During the time period that he was in the community, he was gainfully employed, working full-time as a truck driver for approximately 1.5 years, working at Western Express. He then was working at Lilly Transportation out of Cheshire for approximately 4 months. And he indicates to me that he was working at Lilly Transportation up until the time that he was remanded into custody. His future plans for parole reinstatement include sponsoring back to his parents' house. Again, his significant other resides with his parents. His child is also living in that house. His parents are a big support to them as they are new parents. I did have communications with his parole officer in regards to him being able to sponsor back to his parents' house. She did indicate to me that she did not have a problem with it, that she was going to check with her supervisor. And then I did not hear back. And unfortunately, she was present, but then she wasn't present. So a request would be that he be allowed to sponsor back to his parents. Obviously, his father did submit a letter in support of that. In addition, I think it's important to note that his brother does not reside at that residence. Though he does obviously visit his parents, he doesn't live there. Second to him, his sponsor, I would suggest his sister, Gloria Rodriguez. I will provide you with her information. I'll pass it over to you momentarily. By way of employment, he can return to his employment at either Western Express or Lilly Transportation. He's very employable as a truck driver. He's amenable to all treatment recommendations. Another thing I did speak to his parole officer about was the recommendation that he complete the Explorer program. And I would just note, my client certainly has no objection to completing programming. However, the Explorer program is a program that's designed for serious domestic violence offenders. Oftentimes that involves intimate partner relationships. And in this situation, this was a dispute with his brother. So I would suggest that this does not fall under the need for such a program as the 26-week Explorer program. Certainly my client's agreeable to doing an anger management program, and that would just be my comments in regards to that. Again, my client's eager to return to the community and bond with his newborn child, again, who was born in March. He does have a room set up at his parents' house for the baby, as well as his girlfriend and himself. He does have the support of both of his parents in terms of helping him begin to raise the child, and he needs that support to get back on his feet. His eventual goal is to self-sponsor. And so he has been working towards that goal by way of saving money. And he's certainly able to do that while he's living with his parents. We would be asking, in light of the court disposition, the fact that it's his first violation, the length of period of time that he's been in the community without issue. And I would note that he has no, I don't believe there were any misconducts during the 28-month period of supervision, then he'd be re-paroled at the next available date. Thank you.
thank you. Cheers. So I have listened to the testimony today. I've reviewed all the evidence provided. Based on that, Mr. Pacheco Rodriguez, I am gonna recommend that you approve your revoked and that you serve an approximate 3-month period of confinement. That's with the re-parole date of July 30th, 2026. I'm gonna recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for anger management, no contact with co-defendant Francisco LaBoy, no contact with victim HO. Is your brother's name the same, your name?
Yeah. Yes, Michael Pacheco, yeah.
Okay. I'm not gonna do one for the father, but I am gonna do I'm gonna recommend a general no contact with, MP without your parole officer's permission, so your brother without your parole officer's permission. And I am gonna do a halfway house placement. It's just the family dynamic. I don't know what they're gonna do in the field, and if I release him on the same day as a board review, or if I recommend that and I do it, he might need somewhere to go, so.
So obviously his second option.
I put his sister,
Yes.
but I mean, it's gonna be up to them. I don't know if you guys got that far with him, so I'll put your sister's information, but it's still the same day releases. I don't know
Okay.
what's gonna happen. What location for halfway house would you wanna be in?
Wait. I have a question. So I'm not able to get like released to my father's?
So, I mean, I'm going to give Parole the information that you've asked for your father's first, and then you have your sister's address. It's up to your officer in the community where you're going to reside. They have to approve housing. The problem though, Mr. Pacheco Rodriguez, is that I'm gonna recommend that you be released the same day as the board review date, and they have to do sponsor verification. So they have to go out, check the houses and run background. So I don't know if that's feasible for them to get all of that done and to figure out which house you're going to, if the board adopts the recommendation for you to be released that day.
So Michael, so what she's saying basically is that in the event that the board says that, or that Parole and Community Services says you can't go back, she's just giving you a backup. It's gonna have to be a halfway house. So I would assume you want a halfway house in the Hartford area if you had to go to a halfway house. She's not saying that you have to go to a halfway house, but just in the event.
So you said something about July 30th?
So what happens next is my recommendation is gonna go to the board on July 30th. I have recommended that you be released that day. So if the board, we meet at 9 a.m., if they approve it and adopt it, you'll be released before the day's over. So because of the fast moving of it, it's up to your officer in the community to approve housing. I don't know. I'm just doing it as a backup plans because you have to be released that day. And if they're not going to approve you staying with your father, they might have to do a sponsor background check with your sister, and it could take time. So they have to put you somewhere. They can't keep you in jail. Right, you're on special parole, correct?
Michael, I will email your sister's information to your parole officer today, so she has it at least, okay? Listen. I know she's been in touch with your father. She's told me that she spoke to your father on multiple occasions. She's well aware of his position, okay? And I think she's gonna do the best that she can to get you back to that residence. But she also has a supervisor. And if that person says no, then I'm gonna give her your sister's information, okay? So the worst case scenario is that you would go to a halfway house as a backup to your backup, okay?
To the 30th.
Yeah.
So I have to get released. So for me, it's not on the 28th, it's the 30th?
Correct.
The 28th is a Saturday. You can't be, right? I'm assuming that's why I did 30th?
No, the 28th is on a.
Oh, no, I can't. It's the board review date. You can't go earlier than that. That's the date the board is gonna decide on your case. So that's the earliest date possible is July 30th.
So I get released out of here to a halfway house on the 30th, which is on a Thursday.
Not necessarily to a halfway house. I'm telling you that that's the worst case scenario, is that you would go to a halfway house.
Oh, okay.
I would assume that you would rather go to a halfway house than stay in jail.
Yeah, no, I'd rather,
Okay,
I just.
so if for some reason you can't go to your father's, you can't go to your sister's, then it would be a halfway house, okay?
So the process from now to the 30th, we're gonna be seeing my sponsors before the 30th happens? No. So it's the
Possibly,
28th,
possibly, okay?
okay. And I would know from who would how can I contact anybody so I can know where I'm going?
Why don't you, schedule a legal call with me and I'll reach out to your parole officer in the meantime, okay?
All right,
The
Okay,
problem is, Mr. Pacheco Rodriguez, is that on that date, they really don't know either. None of us know what's gonna happen on July 30th, because the board, as I explained, can keep you longer if they want to. They can ask you to come back and speak with them for another hearing and keep you longer. So no one can actually make moves until 9 a.m. that day on July 30th. And because I'm recommending you leave that day, it's fast paced and it's fast moving. So they can, I don't know how Parole and Community Services works. They could possibly be reaching out to sponsors in the next 2 weeks, but they don't have a set answer either. No one knows until 9 a.m. on July 30th. So worst case, as your attorney has said, is that you go to the halfway house and you work with them out there to get to a sponsor's home. Because you don't have to stay in a halfway house. They want you to be in with a viable sponsor. It's just that there's back work to get to a sponsor. And because of the situation at your father's house, your parents' house, and your brother, counsel did mention he does still visit them. There's more going on with your family dynamic. So it's up to them out there.
So
I'm
when-
assuming
I got a
Officer McHugh,
I got a question too. When am I able to speak to my brother?
you have to talk to your supervising officer before you can. You have
Yeah,
to talk with,
It just doesn't, yeah, I had to talk to them because that's my brother. We're talking about 8 more years of special parole that I can't speak to my brother. That
Well,
doesn't even make sense to me.
why you talk to them about it and you
Yeah.
discuss it. I mean, the reason why you're in jail is because you talked to your brother, and that's what we're trying to alleviate. You talked to
Yeah.
your brother and you guys got into a fight. That's why you're in jail. Otherwise you wouldn't be here. So I know it sounds crazy, but from our standpoint, the only reason you're in front of me is because you talked to your brother that day. And look where it ended up.
Yeah, no, I understand that.
So you have to have the conversations with your supervising officer that me and my brother have worked on this. This is where we're at. And it's up to them to give you permission, whether or not to be in contact with him. Because we don't want you to be in jail. That's the whole point of this. We don't want you here. We don't want you to be incarcerated. So these are just guidelines to hopefully not have this happen.
All right. Okay, I appreciate it.
All right. Any other questions?
No.
All right. So ideally, I mean, you won't hear from any, well, you're gonna do
you
a legal
can reach
call.
out to me. I'm gonna contact your parole officer. I'm gonna let her know your sister's information, just in
Yeah.
case, okay?
Is there any way I can have my my girlfriend reach out to you and ask you questions so she can know? Just in
Yes.
case if I can't get a hold of you?
Of course, yes,
Okay,
okay?
all right.
All right.
Okay.
And like I said, best case, like you'll be walking out the door that day of the hearing. You won't even get the paperwork in the mail because you'll be already in the community, okay?
Okay, I know how the halfway house is and I don't want to be in a halfway house. There's
It's
too
not-
much going on in halfway houses and
It's not
I'd rather
permanent.
not even, yeah, I could already violate just being in there from other people doing stupid shit and I'm in the same room and apartment as them. So I wouldn't even want to be in a halfway house. So it's like,
Just relax, okay?
Yeah.
all right, all right, thank
Michael.
you. Thank you so much.
This concludes the revocation hearing for Michael Pacheco Rodriguez, inmate number 372435.
Can I leave? I
Yeah,
can
you're
leave?
all set. Thank you.
All right,
Good luck
thank
to
you.
you, okay?
You too.
Hi.
Medical staff underway.
We're all set, thank you.
Okay,
Thanks.
no problem.
Hey, how are you?
Good, how are you?
Good. Can we see Mr. Barker first, please?
Sure.
Thanks. Hi, Mr. Barker.
Morning.
Morning. Good morning. Yeah, all right, so we're gonna get started, okay, Mr. Barker?
Yes.
All right, so good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Adrian Barker, inmate number 3301196. Today is Wednesday, July 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Adrian Barker, inmate number 330196.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you, Attorney Sonia Jones, on behalf of Mr. Barker.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that the preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Barker, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charge that the state or parole officers bring against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegation. At the conclusion of this hearing, I will inform you of my finding, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charge of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to submit evidence in support of your case. You have the right to review the evidence against you before this hearing, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, so we'll now review the charge that the state, your parole officers bring against you, and the information underlying each charge. So it is just the one charge, and I am going to just note on the record that it was a signed warrant. So it does state that on 8/10/25, the offender's address was changed to unknown absconder, Waterbury, Connecticut 06702. After a compliance check found that his reported address on 27 Johnson Street, Waterbury, CT was no longer valid. I just want to skip to that part because, like I said, there was a signed warrant that it states that on 11/4/25, the offender violated his registration requirements on one occasion and violated Connecticut General Statute 54-252. So counsel, I'm not going to review all of the detailed information, or do you want me to read it?
No, that's
word for word? Okay. So ideally we wouldn't take any testimony towards that, but, I do just want to identify the exhibits that have been filed for the record as well. We have Exhibit A, the remand to custody, Exhibit B, the notice of parole violation, Exhibit C, the conditions of parole, Exhibit D, the parole violation report, Exhibit E, the Waterbury PD arrest warrant, Exhibit F, the sex offender registry investigative report, Exhibit G, the judicial pending case detail, Exhibit H, the decision information summary, Exhibit I, the preliminary summaries for past parole violations, and Exhibit J, the parole revocation summaries for past parole violations. So counsel, just confirm you and your client did receive the parole violation, the parole notice of parole violation, the parole violation for and all the other documents identified for today.
Yes.
And I have not received any exhibits from the defense at this time. Counsel, do you need time to submit anything?
No.
Okay, so it is now your opportunity to make a statement and to testify towards the case. So counsel?
Yes, thank you. I understand that there was a signed warrant in this case. However, my client did appear in court relatively quickly and did dispose of this matter. On July 10th of 2026, the matter was dismissed in court. The reason that the matter was dismissed, my understanding is that this was conduct that was duplicative of a previous warrant where he was charged with the exact same thing and violated in parole. He was resolved that matter February 26th of 26 after having been in custody for approximately 3 months on that matter. So based on all of that information, the state's attorney's office, it's my understanding the state's attorney's office requested the dismissal from the judge, and the dismissal was granted. I do have a copy of that. And again, that occurred on July 10th of 2026. So we would ask that there not be a finding of probable cause. But notwithstanding that, if you make a finding of probable cause, then we would ask that the matter be considered not serious to continue to incarcerate him, as obviously the case was dismissed. But certainly, just because a warrant was signed doesn't necessarily mean once the case went to court that there was enough to pursue the case, as obviously there was not, and there was a dismissal.
Thank you. I'm just going to take a moment and then I will announce my finding. So counsel, just to confirm, you mentioned that it's the reason of the dismissal was because it was duplicative. It was the same behavior that he was already charged with. in
Right,
another
and
warrant, prosecuted, and
Correct. And then for some reason, this did not, this warrant came up in April. Right.
And he was convicted of that as well back in February.
Yeah, so in February, he did enter a plea on that charge and he received an unconditional discharge. But I would even note at the time that that case was pending, the court issued a promise to appear and asked that Mr. Barker be released on that matter. However, he was obviously unable to be released because he was held on a parole remand, noting that his underlying conviction was the only conviction that he had on his record. And that's the matter that he's on parole for. Now, certainly having been convicted back in February, he now has 2 convictions on his record, or 2 separate incidents. But at the time, that underlying conviction was the only matter that he had on his record. And the judge noted that at the time that he was arraigned. And that was the basis for why the judge was asking or issuing a promise to appear.
Oh.
And we previously submitted a transcript on that February case, but it's not submitted here. But I just would note that it was previously submitted and it does indicate that.
Oh. When you say previously at his last revocation.
Exactly, yes.
Actually, we do have the summary. I'm just going to review the summary quickly. I think they provided it, right? Just to review it. No, this one. Maybe we don't have it. Was it at the prelim? This one's old too.
Oh, there was a previous, it looks like there was a violation from 2019.
They're all old.
And then I don't have anything information on it. 20. Okay, here's one up to why that was. So I don't,
Oh, here we go, February 18th of 26.
is that Jay?
Yes. Yes. Let's see. Yeah, the transcript's in there. They mentioned the trans. Author, please, got it. Okay. Okay, Mr. Barker, so I have listened to the testimony today presented, before me. With that, I'm gonna make a no finding of probable cause. Because I do not believe that you did violate your parole, and I'm gonna reinstate your parole effective today, okay?
Thank you.
So I'm gonna notify the records office at the facility now, as well as your parole officer, and, they should be releasing you today. I'm gonna get the paperwork done now, so it gets moving, okay?
Thank you.
All right, anything additional, council?
No, nothing additional.
Okay, all right, well, good luck to you, Mr. Barker, okay? Make sure you just keep it up with the registry, okay?
Yes, ma'am. Thank you, Ms. Jones.
You're welcome, good luck.
This concludes the preliminary hearing for Adrian Barker, inmate number 330116. All right, good luck to you, Mr. Barker.
Thank you.
Thank you, council.
Waiting for the next one?
Yeah, that's fine. You can have them come in. Attorney Dean, I just need a moment to process the paperwork. Yeah, you can have them come in. I'll let them know.
No rush, thank you.
Thank you. Good morning, Mr. Wisnett. How are you? So I just need it like 2 minutes. I just have to process the paperwork for the gentleman before you, and then we'll get started, okay?
Yes, ma'am.
Thanks. Sorry, Trina, I just saw your email. With me and Officer Menard. You're okay to move forward right now?
I think so. Your next hearing's 11:15, correct?
Yeah. So
I think his is 11:30. So
Okay.
yeah, we should probably, I think, do this one first. Thank you.
Okay. All right. Sorry about that. Thank you.
No worries. Thank you.
So good morning, I'm Parole Officer Trishelle, and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Daniel Wisnett, inmate number 253715. Today is Wednesday, July 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Daniel Wisnett, 253715.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Deed on behalf of Mr. Wisnett.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better weight or evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Wisnett, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will is not present on today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, so you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We will now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So in charge number 1, the condition of GPS, the charging officer reported that upon your release into the community, you were placed on GPS monitoring. You read and initialed and signed the GPS monitoring agreement. On 5/7/26 at approximately 9:12 a.m. while in the community, you cut the GPS unit strap. You discarded the GPS unit later located at Walmart. Your whereabouts in the community are unknown. Charge number 2, the condition of program participation. The charging officer reported that you were referred to the Connection Center for Treatment of Problem Sexual Behavior, which you are stipulated to attend. You signed the CT-PSB treatment agreement on 2/10/26. You were unsuccessfully discharged from the Connection CT-PSB treatment on 5/14/2026. You were also referred to the Hartford AIC to attend CBT reasoning and rehabilitation. You were unsuccessfully discharged from R at 5/7/26. Charge number 3, the condition of residence. The charging officer reported that you were released to special parole on 1/28/26 and placed at the Aileen O'Connor halfway house, which was subsequently your only parole-approved residence due to a lack of valid sponsor in the community. On 5/7/26, you were issued a pass to attend CT-PSB treatment group at the Hartford District Parole Office. You failed to report to the parole office and alternately deviated, arriving at Walmart at Hartford at approximately 9:06 a.m. At approximately 9:12 a.m., you cut your GPS unit strap and discarded the unit in Walmart. You never returned to your only parole-approved residence, and your whereabouts in the community are unknown, and attempted to locate you has been unsuccessful. On charge number 4, the condition of absconder, the charging officer reported that you will be released to special parole on 1/28/26 and placed at the Aileen O'Connor halfway house, which was subsequently your only parole approved residence due to a lack of a valid sponsor in the community. On 5/7/26, you were issued a PASTA 10 CT PSB treatment program in the Hartford District Parole Office. You failed to report to the parole office and alternately deviated, arriving at Walmart in Hartford at approximately 9:06 a.m. At approximately 9:12 a.m., you put the GPS unit strap and discarded the unit in Walmart. You never returned to your only parole-approved residence, and your whereabouts in the community are unknown, and attempts to locate you have been unsuccessful. Charge number 5, the condition of halfway house placement. The charging officer reported that you will be released to special parole on 1/28/26 and placed at the Aileen O'Connor halfway house, which is subsequently your only parole-approved residence due to a lack of a valid sponsor in the community. On 5/7/26, you were issued a PASTA 10 CTPSB treatment group at the Hartford District Parole Office. You failed to report to the parole office and alternately deviated, arriving at Walmart in Hartford around 6 a.m. At approximately 9:12 a.m., you cut the GPS unit strap and discarded the unit in a Walmart. You were never returned to your only parole-approved residence. Your whereabouts in the community are unknown, and attempts to locate you have been unsuccessful. You violated condition number 1 and 2 of the DOC halfway house agreement. On 1/30/26, you signed the DOC halfway house agreement for Aileen O'Connor halfway house. On 3/24/26, during a random search of your assigned room and related area, you were found to have and concealed an amount of marijuana underneath your assigned bedside table. You violated condition number 9 of the DOC halfway house agreement. On that states, I will not consume or possess alcohol or marijuana in the halfway house. On 3/24/26, you signed a residential discipline report. And on 3/30/26, you signed a misconduct, admitting to having possessed and concealed marijuana in the confines of the halfway house. You violated the DOC halfway house agreement number 1. I will not leave the physical confines of the halfway house unless authorized by program staff or parole. And I will only go to locations indicated on the above approved community pass unless changes have been authorized by staff. You violated this condition on the following dates: 2/11/26, 2/13/26, 2/16/26, 2/18/26, and 5/6/26. On these dates, you intentionally deviated from the only approved location on your halfway house pass, failing to comply with the halfway house rules and subsequently being unaccountable in the community. You violated DOC halfway house agreement number 2. I will return to the halfway house for my community pass at my scheduled return time on the following dates: 2/11/26, 2/13/26, and 2/18/26. On these dates, you failed to return to the halfway house within the specified time, returning past the end time of your issued halfway house pass. In charge number 6, the condition of problem sexual behavior treatment. The charging officer reported that you were referred to the Connection Center for Treatment for Problem Sexual Behavior, which you were stipulated to attend. You signed the CT-PSB treatment agreement on 2/10/26, and you were unsuccessfully discharged from the Connection CT-PSB treatment on 5/14/26. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to custody order; Exhibit B, the notice of parole violation; Exhibit C, the parole violation report; Exhibit D, the parole conditions; Exhibit E, the GPS monitoring agreement; Exhibit F, the CTPSB treatment agreement; Exhibit G, the DOC halfway house agreement; Exhibit H, the Connection CTPSB unsuccessful discharge letter; Exhibit I, the misconduct reports; Exhibit J, the residential discipline reports; Exhibit K, the halfway house incident report; Exhibit L, the Community Solution Inc.'s abscond report; Exhibit M, the surveillance data center email dated 5/7/26; Exhibit N, the Allied Universal Strap violation report dated 5/7/26; Exhibit O, the Allied Universal position histories; Exhibit P, the secured message schedule - halfway house pass log; Exhibit Q, the PBR fugitive of February 2022 and October 2023 and January 2025. Exhibit R, the revocation summaries April 2023, April 2024, and March 2025. Exhibit S, the New Britain Police Report number 12-9021. Exhibit T, the BOP decision information summary. Exhibit U, the RT60 absconding history. And Exhibit V, the CPA Hartford AIC email and unsuccessful discharge report. The state did file an addendum to the parole violation report on January 16, 2026 that states on 5/26/26, that can't be the right date, but they did submit an addendum to the parole violation report that states that on May 26, 2026, the Board of Parole issued a warrant based on the report declaring the offender an absconder from parole supervision. On 5/27/26, the case was transferred to the fugitive investigations unit and considered a high priority case. And on 6/10/26, FIU apprehended the offender walking down the street. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes, we have. Thank you.
Perfect. I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
Not at this time. Thank you.
Don't have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to the charges. So counsel?
Yes, thank you. I just wanted to know that this was an unfortunate situation. My client has, leading up to this point, lived a very hard life and has struggled tremendously with trauma. At the time these alleged violations occurred, my client unfortunately was not taking his medications. He reports previously, while incarcerated, they had him taking Wellbutrin to treat PTSD, and he found that to be very helpful. Unfortunately, my understanding is that upon release, he tried speaking with his doctor and pharmacist to advocate for himself to get back on that medication, but they declined to prescribe it to him, which left him in a vulnerable place. He acknowledges this in many ways led to him making some poor decisions while on parole. I will note he was also feeling discouraged concerning his job prospects. He reports applying to numerous positions with the support of the job coordinator staff at Eileen O'Connor. However, he felt that parole, his PO, was not offering that same level of support and was discouraging places from giving him a chance. He, we're not denying that my client's on parole for a serious matter. However, he is trying to move forward with treatment, medication management, and employment so that he can be a productive member of society. And he does report that there were multiple times where he would utilize, the job coordinator to help him apply to positions. He would talk to those places, ask if they needed background checks or additional information, which they would decline. And then, unfortunately, he reports parole would call, and then all of a sudden the job wouldn't be available, which I think kind of led to him being frustrated with the process. I will note that despite all of this, my client was forthcoming to parole and the halfway house staff about any misconducts or sanctions he was given. He told his PO the truth about his whereabouts, despite knowing he would be sanctioned for that behavior. As to the actual charges themselves, charge 2 program participation, I would argue there should be a partial no finding as to the second half of the charge concerning the AIC CBT group. I would note that the discharge and evidence exhibit V is an email from AIC indicating about his intake and recommended treatment, but the attached discharge report is not from that program. It is from the CTPSB discharge report that is also at Exhibit H. So for that reason, I would argue there should be a no finding. I will also just note that while he was engaged in the CTPSB program, he was attending consistently and was engaged in those sessions. And we would at the appropriate time like to speak to his background and history. Thank you.
Thank you. I'll just take a moment and then I'll have my finding. Okay, so on charge number 1, the condition of GPS, I am making a finding that you violated that condition based on evidence presented in states exhibits C, D, E, K, M, and N. On charge number 2, the condition of program participation, I am going to identify as 2 separate parts, each part identified with each program as charged, and I am going to make a partial finding. So I'll make a no finding for the part about AIC. As counsel stated, there is no discharge summary, no information about that from the AIC. However, I am going to make a finding that you violated that condition for the CTPSB program based on the evidence presented in states exhibits C, D, F, H, and B. Not B. So just up to H. So C, D, F, and H. On charge number 3, I am finding you violated the condition of residence based on the evidence presented in states exhibits C, D, K, and L. On charge number 4, I'm finding you violated the condition of absconder based on the evidence presented in State's Exhibit C, D, K, and L. On charge number 5, the condition of halfway house placement, I am making a finding that you violated that condition based on the evidence presented in State's Exhibits C, D, G, I, K, and L. And lastly, for charge number 6, the condition of problem sexual behavior treatment, I am finding you violated that condition based on the evidence presented in State's Exhibits C, D, F, and H. So it does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So counsel?
Yes, thank you very much. My client is 45 years old, born and raised in New Britain. He does have family support in the area, including his mom, sisters, and 2 brothers. He also has a sister who resides in Florida. My client did very tragically lose his father in an extremely tragic way in the early 2000s. He does also in the community have 4 children, ages 25, 24, 22, and then his youngest is 2. Previously, while on supervision and residing at Renaissance East, he obtained his OSHA 10 and flagging certifications. He was working with the Best Chance for a Second Chance program when he was just most recently at Eileen O'Connor to start a culinary arts degree. He utilized the Capital Workforce Partners for employment assistance in addition to the Halfway House employment partners. He reports attending a job fair in Windsor while in supervision and also obtaining a few different job offers at one point. He reports last employment around 2023 at Ridge Products Corporation in New Britain. He was doing treatment in the community, including CBT. First, he was doing it at Eileen O'Connor, and then he started at AIC and also added the R&R treatment in addition to his CTPSB treatment requirements. Previously, he did engage in Wellmore in Waterbury. He is hoping upon reinstatement of special parole to be sponsored at a halfway house in Waterbury. He plans to enroll in a CNC machining program and culinary arts to further his education and job prospects. He's interested in looking into a construction job while in school for those things, but is open to any sort of opportunities in the community. And he's open to any treatment recommended as well. I am asking that you would consider a sanction not to exceed 6 months for my client. He was, I think, only in absconder status in the community for less than a month. Again, he was forthcoming with his parole officer about any prior issues he had, and he is very much looking forward to trying to move forward and get a job when he gets back out. Sir, is there anything that you want to say that I didn't cover about your plans or your background?
Right now, I can't even still get my meds still, so like I'm still dealing with that right now and stuff. And I don't know how they told me to write to mental health. I wrote to mental health and I didn't get no answer since I talked to you.
I'll reach out and I'll set up a call with you and I'll talk about other options, see what we can do, okay?
I'm doing my best in here. I'm not getting in trouble. I'm staying to myself. I got a good celly. I talk about my situation. You know what I'm here for. I don't lie about nothing and stuff. And he a good dude. He tells me that's your past. And I'm just taking day by day. I'm just learning from my mistakes what I did. Like I said, like how you told the lady right here. I'm just trying to do the right thing. I'm not trying to do bad things no more and stuff. I'm just trying to go home and get a job and stuff. And I feel like when I went to Hartford, I had my last parole officer. They're the same person. They work together. So I feel like they was gunning me down for no reason. How was to get a job if you calling the place up and saying, "Oh, we need to do a background check on it." Then I already asked them, if you can do a background check on me, they tell me no. So why are you gonna go back and mess my time up and make me feel bad, make me feel guilty of something I didn't even do? That's all I'm gonna say. Thank you.
Thank you.
Just gonna take a moment, then I'll announce my recommendation. So do you just want to know on the record, Mr. Wisnett, this is your fourth violation on special parole, and you have only been on special parole for 5 years. So you continue to violate, and it's repetitive behavior. It's all the same stuff: GPS, absconding, residence, halfway house. It's just repetitive. So the behavior is not changing out in the community. You were only out in supervision for approximately 3 months and 1 week between when you were re-released and when you absconded. I do understand what council stated, that you were only unaccountable for 1 month. And I do want to also know on the record that Parole and Community Services has recommended a full revocation, and you have 6 years of special parole left, and they have recommended that you serve that full 6 years incarcerated. Especially in the addendum when they mentioned that you were high priority case. It's just concerning that your behavior is, like I said, repetitive. It just keeps happening. So with that, Mr. Wisnett, I'm going to recommend that your parole be revoked and that you serve an approximate 18-month period of confinement as a sanction. That's with a re-parole date of December 10th, 2027. I'm going to recommend the following conditions: no alcoholic beverage consumption, no contact with victim SW, mental health evaluation, no contact with minors, problem sexual behavior treatment, and halfway house placement. So what happens next, Mr. Wisnett, is that my recommendation is going to go to the board on July 30th. On that date, the board can do 3 things. They can lessen my recommendation. They can choose any day they want between July 30th and December 10th, 2027. They can adopt my recommendation if they choose to do so. And then if for any reason they would want to see a longer period of confinement as a sanction, they will ask you to come back for another hearing to address their questions and concerns before they impose anything longer.
So how much you recommend me?
Recommended 18 months. So
The recommendation would be, sorry,
that's
for
okay.
for you to get out December 10th, 2027. So not this year, but next year. That gets voted on July the 30th by the parole board, and they can do one of 3 things. They could potentially give you less time. They could potentially give you more time. If they did that, we would get another hearing, or they could accept what was recommended. So we'll know for sure on July the 30th, and then you'll get a copy of that in writing afterward. But I'll set up a call with you so I can talk to you as well about the medication situation.
Thank you.
Thank
This
you.
does include the revocation hearing for Daniel Wisnett and meet number 253715. Very good luck to you, Mr. Wisnett. Thank you, Attorney Dean.
Thanks, everyone.
Good morning.
Good morning.
Been feeling
It's just going to be a few minutes. We had a code, so he's just being escorted up. It's going to be a few minutes.
Okay, thank you.
You're welcome.
Should be all set.
Great. Good morning, Mr. Rivera. Attorney Jones is here. Officer Bennett, are you with us?
Hey, can you do me a favor?
I am sorry. I wasn't sure who you were waiting for. I just kind of popped in.
No, you're okay. Thank you. So I just want to go on the record. I am Parole Officer Giselle. This is a revocation hearing concerning Rafaelito Rivera, I mean, number 413226. So Officer Bennett, I think you were attached to the emails. We did receive an appearance from the state's the public defender's office yesterday, as well as a continuance, and I am going to grant the continuance to them for representation. Counsel, any statements at this time?
No, simply that we're asking for August 13th. Thank you.
Okay, so I am gonna grant that continuance, that way that you guys have enough time for preparation as stated on the continuance. So Mr. Rivera, we will see you on August 13th with your attorney present. Officer Bennett, will you be present on that day?
All right.
Will I be likely? Yeah. P.O. Richardson is now P.S. Richardson. She got promoted. So someone from the mental health unit will fill in to do the revocation hearing with you.
Okay, so someone will respond when I send out the tentative docket. Okay, perfect. All right, so then Mr. Rivera, we will see you on August 13th, okay?
All right.
All right, thank you, everybody.
Thank you.
Good morning.
Good morning, how you doing?
Good, how are you?
Good. Who are you waiting to see now?
I need to see Mr. Vasquez and Luis Finn.
Okay, I'm gonna call them down, so just hang on a minute, okay?
Okay, and if they get down, if we could see Vasquez first, that'd be great. If not, whoever gets there first.
It's Vasquez, you said?
Yes, Vasquez.
Okay, hold on 1 second.
All right, thank you.
Yep. He called Delta 120, we need Vasquez down here. No, but I heard the thing going up. I thought Dan, I thought Mercy were not doing it. Delta 120 Vasquez. What's the seat? Here we go. Formal now. You have to see what happens, and I leave for a second and then fuck it up. No, everything's clear. Yeah, the book window is clear. Yeah, so that's good. Hello? Vasquez is on his way down.
Okay, and Louis Finn, is he there or not yet?
No, not yet. We're gonna get him, because he's in a gang unit, so we'll go get him. How long do you think you'll be with Vasquez?
Ideally 15 minutes.
Okay, so we'll go get him as soon as he gets here. We'll go down and get him, because they can't be together.
They can't be, no worries. We can take our time. You guys are my last facility, so whatever you
Okay.
need to do.
All right,
Okay,
he'll be
perfect.
down in a couple of minutes.
Okay, thank you.
You're welcome. Well, not visible. Visible? When you get done, just knock on the window and I'll come get you out.
Yes, sir.
Good morning, Mr. Vasquez. How are you?
Good and yourself, good morning.
Good. Just waiting for us to move your charging officer in to the meeting. And then we'll get started.
I'm here. I don't know if you can hear me.
I can see you and hear you. We just need you to, well, I need to, there we go. Perfect.
Good morning.
Good morning, everyone. So good morning. I am Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is the preliminary hearing concerning Wilmer Vasquez, inmate number 371-536. Today is Monday, July 15th. No, it's not. Have I been saying Monday all day? You're my last person. You're number 9, and I think I've been saying that all day. Today's definitely Wednesday, and it's July 15th. Oh boy. All right. I'm going to start one more time, okay? Today is Wednesday, July 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Center. Please state your full name and DOC inmate number for the record.
Wilmer Vasquez, 371-536.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your charging officer. Can you please identify yourself for the record?
Sure. Parole Officer Esposito, Norwich District Office.
Thank you. So this is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there is probable cause to be committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. What threw me off, Mr. Vasquez, is that you do have pending charges. Is that correct?
No, I took 30 days run concurrent with my special parole violation.
So it's already over. Okay, because I was gonna let you know you do have also the opportunity to waive today's hearing. So you want to move forward with today's hearing then?
Yes.
Okay. So you should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Vasquez and Officer Esposito, can you both please raise your right hands? You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
I do.
Yes.
So I'm now gonna go over the procedure for today's hearing. So first I'm gonna read your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights, and I want to review them with you now. You have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Mr. Vasquez, were you informed that an attorney could represent you at today's hearing?
Yes.
And do you intend on seeking counsel for it?
No.
So one more time to confirm, you are willing to move forward today without legal representation?
Yes.
You also have the right to receive written notice of charges of violation. Did you receive that written notice?
Yes.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I understand. I'm ready to go forward.
Thank you. So at this time, we are now going to review the charges that the state parole officer is bringing against you and the information underlying each charge. So Officer Esposito, can you please review the charges for us, starting with number 1, obedience to the law?
Sure. Charge number 1, obedience to the law. On 6/16/26 at 13:43 hours, you were driving a motor vehicle and you were observed by police traveling at a high rate of speed. Police obtained a speed of 94 in a posted 65 mile per hour zone. You made numerous unsafe passes and around traffic as police attempted to stop you. You accelerated to speeds greater than 100 miles per hour, and you only slowed and yielded once police caught up to the vehicle you were operating. You do not have a driver's license and only adult learner's permit. You were previously cited by Ledyard Police Department for operating without a license. You were issued a summons for 1 count of reckless driving over 100 miles per hour. Count 2, it should be count 2, failure to obey an officer signal. Count 3 is unsafe passing, and count 4, operating a license without a license. It should be operating a motor vehicle without a license. Based on your actions, you are in violation of special parole condition, obey all laws. To charge number 2, drugs, on or about 5/27/26, you used cocaine. The specimen was sent to Premier Biotech Labs LLC and was confirmed positive for cocaine on 6/2/26. To the charge of number 3 of no driving, on 6/16/26 at 13:43 hours, you were driving a motor vehicle and you were observed by police traveling at a high rate of speed. Police obtained a speed of 94 in a posted 65 mile per hour zone, and you made numerous unsafe passes around traffic as police attempted to stop you. You accelerated to speeds greater than 100 miles per hour, and you only slowed and yielded once police caught up to the vehicle you were operating. You were not given permission to operate a motor vehicle without another adult present. Based on your actions, you were in violation of additional condition, no driving.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for us?
Yeah, Exhibit A, signed statement of understanding and agreement of conditions of parole. Exhibit B, remand to custody order. Exhibit C, violation notice of parole violation. Exhibit D, parole violation report. Exhibit E, Connecticut State Police summons ME 042801. Exhibit F, misconducts, and Exhibit G, Premier Biotech Labs LLC.
Thank you. So Mr. Vasquez, did you receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes,
And you were able to review all of that evidence?
yes.
I have not received anything from you at this time. Do you need time to submit any documents for your own behalf?
No.
Okay, and we do not have any witnesses. So at this time, it is the state's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. So Officer Esposito, any statement at this time towards the charges or severity of the allegations?
Yeah, I just want to say that, he had, while he was supervised by the officer in Waterbury, he had an incident with Ledyard Police. And at that time, he was given a misconduct about driving. And then with this incident that happened, I mean, he was exceeding very high speeds and, over 100 miles per hour. So I felt it was serious enough for, after he had already been warned about driving. And he was in the process, though, of getting his license, but just hadn't got his license yet. But he knew that he wasn't supposed to be in the car without another driver since he only had an adult learner's permit. So that's pretty much all I need to say about those charges. I also would like to know, I don't know if you want me to do it now or not, he was sentenced on these charges on 7/8/26 to the reckless driving. I did do an addendum yesterday that I submitted. He got 30 days mandatory minimum for the reckless driving charge. Counts 2, 3, and 4, which is disobey an officer's signal, unsafe passing, and operating a motor vehicle without a license. Those charges were nollied. But I did submit that addendum too yesterday. But that's it.
Okay, thank you. Thank you. So Mr. Vasquez, now is your opportunity to respond to the parole violation charge against you. However, remember that you do have the right to remain silent if you choose to do so. So at this time, would you like to make any statements towards the charges and the severity of the allegations against you?
I mean, all I gotta say is, I understand what I did wasn't right and apologize for that and proceed with the hearing.
Thank you. I'm just going to take a moment and I'll announce my findings. Okay, so for charge number one, Mr. Vasquez, I've identified it as separate charges and I'm gonna make a partial finding. Each part is identified as a charge against you as stated in the violation notice. So I am making a finding, for the reckless driving based on your conviction, not conviction, based on the evidence presented in states exhibits A, D, and E, as well as the testimony provided by the state today, and as well as you that you were convicted of said charge. I am making a no finding of probable cause for the charges of failure to obey a signal, officer, unsafe passing, and operating a motor vehicle without a license, as they're considered in fact infractions and not crimes. Charge number two, the condition of drugs. I am making a finding of probable cause based on the evidence presented in states exhibits A, D, F, and G. And charge number three, the condition of no driving. I'm making a finding based on the evidence presented in states exhibits A, D, and E. I am also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await the revocation hearing. So your officer is aware of it. The facilities records office will be notified of this. So what happens now is that since Officer Esposito already submitted the addendum, it just takes time for my supervisor to process it. I think, did your supervisor approve it already too, Officer Esposito? Do you know?
I don't think he did. I submitted it yesterday. I don't think I think it's still,
Pending.
yeah, and he's in training today, so.
Okay. And like they
I
have
would assume
14
tomorrow.
days. Yeah, they have 14 business days from whenever the disposition is to get it to us. And she's already done her part. So once it's over here at the board, we will then schedule you for that revocation hearing, okay?
All right.
All right, any questions at this time?
Nope.
All right, so this does conclude the preliminary hearing for Wilmer Vasquez, inmate number 371536. All right, good luck. All right, we'll see you soon. I think we'll see you soon. All right, Vasquez. Thank you, Officer Esposito.
Thank you.
Thank you.
All set?
Yeah.
Yeah, Ron. We're gonna go get the other guy. It'll be a couple minutes, okay?
Okay, perfect. Thank you.
Yep. My fault, man. My fault. Yeah, you're welcome. I'm like,
Hi, Mr. Lewiston. How are you?
I'm good, and you?
Good, thanks. We're gonna get started, okay?
Hmm?
So good afternoon, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jean Louis Finn, inmate number 401056. Today is Wednesday, July 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Jean Louis Finn, 401056.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Louis Finn, can you please raise your right hand?
My right hand?
Yes, please. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yeah.
Did you raise your hand? Do you have your hand up?
Yeah, I'll raise it. I'll put it back down, but yeah, yes.
Okay, thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose for procedure before we begin?
No.
Okay, so you have important rights, and we're going to review them now. You have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So were you informed that an attorney could represent you at this hearing?
Yes.
Okay, and do you intend to seek counsel? Do you
No.
intend to hire? You don't intend to hire anybody? Okay.
No.
So one more time, you're just willing to move forward today without legal representation?
Yes, that's correct.
Okay, so you also do have the right to receive the written notice of charge of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charge that the state your parole officer is bringing against you and the information underlying that charge. So charge number one, the charging officer reported under obey all laws is that on 3/27/26, you were arrested by Ansonia Police Department. For the state of Connecticut Superior Court arrest warrant on 2/26/26, you went to 370 East Main Street at the spot and went inside the establishment where your niece and her cousin were. You started grabbing your niece's belongings, including her phone and purse, and you hit her several times in the face. A fresh scratch was visible on her chin at the scene per the responding police officer. As a result, you were charged with Connecticut General Statute 53A-61 assault third degree and Connecticut General Statute 53A-181 breach of peace second degree on 3/27/26. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the conditions of parole, Exhibit C, the parole violation report, Exhibit D, the notice of parole violation, Exhibit E, the notice of parolee rights, Exhibit F, the state of Connecticut Superior Court arrest warrant, and Exhibit G, the state of Connecticut Judicial Branch pending case detail. The state did file an addendum to the parole violation report on June 8, 2026 that reads that Louis Finn received an unconditional discharge for a guilty plea for assault third and a nollie for the breach of peace second under docket ending in 209S on 5/27/26. So one more time, Mr. Louis Finn, did you receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
And you were able to review all of that information?
Yes.
Okay, I did not receive anything from you at this time. Do you need time to submit any documents on your own behalf?
No.
And we do not have any witnesses. So at this time, it is now your opportunity to respond to the parole violation charge against you. However, I do want you to know you have the right to remain silent if you choose to do so. So at this time, would you like to testify regarding your case and the charge against you?
I remain silent.
Then I am going to announce my finding. So on charge number 1, I am finding that you violated the condition of obedience to the law based on your conviction of the assault. Third, when you received that unconditional discharge. In addition, the evidence in support of the charge is states exhibits B, C, F, and G. So that does conclude the fact finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So Mr. Lewisman, any comments or statements towards what your plans are, your release plan? Where are you going to work? Where are you going to live? Stuff like that.
I mean, I still got my job.
What's that? What's your job?
I was working at an oil change company.
Like
But
delivering oil? You deliver?
No, doing oil changes. Sorry about that. Doing oil changes.
Okay.
Yeah,
What's the company?
Valvoline.
Valvoline. Okay, so you can go back to it?
Yeah, I go back to it.
Okay,
But I also got my CDLs. I had got my CDLs while I was home, and it basically just get back in, minor setback, but just being productive when I get back out there.
Okay. So your CDL is valid and everything too?
I got my CDLs.
Cool. All right. What about housing? What's your plan?
I still live with my family member. I'm still good over there.
All right. Who is it? I need who they are, their names, their address, and phone number.
That's my sister. I thought it would have been on file, but her address is 90 Beardsley Park, here. And
What city?
Bridgeport.
What's her name?
Gessie Lewis Finn.
No, I need her phone number. What's her phone number?
475-300-5892.
Okay, does this niece live in the house with you?
No.
She's not in that home? Okay. All right. Anything else you'd like the board to know? Any of your other plans about any treatments? Did you complete treatments? Anything like that?
Yeah, when I first got released, I had programs or whatever that I was in, but I completed all my programs.
You've been out for a long time, right?
Yeah.
All right. Anything else before I announce my recommendation?
No, nothing else.
So thank you for talking to me today. I appreciate it. I have reviewed all of the evidence submitted. With that, Mr. Lewisman, I am going to recommend your parole be revoked and that you serve an approximate 4-month period of confinement as a sanction. That's with the re-parole date of July 30th, 2026. I'm going to recommend the following conditions. Behavioral management program for anger management, no contact with victim JP and KM, and a general no contact. Is your niece's initials SJL, the victim of this case?
Yeah.
Okay, so no contact with SJL without your parole officer's permission. And I will put the sponsor information in, but I'm also going to do a halfway house placement just because what's going to happen is that my recommendation is going to go to the board on that same day. So on July 30th at 9 a.m., I'm going to see them, give them my recommendation, and they're going to vote on it and decide. So if they agree with my recommendation, you'll be released that day. So ideally, parole out in the field will have your housing situated before that date, possibly, but if not, they need somewhere to place you until they get it straightened out in the community, okay? So that's what's next. So on that date, I'm going to submit this to the board. They only have two options. They can adopt the recommendation and will be released by the end of that day. Or if they want to see a period of confinement longer than what I've recommended, they'll have you come back for another hearing to address their questions and concerns before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
No questions.
No questions? All right, well, good luck.
Wait, matter of fact, one question. You said that this hearing is supposed to be public?
It is public. Everybody across the world is watching us right now, unfortunately.
Oh, man.
Or fortunately, if that's what you wanted. But yeah, unfortunately, it's all over the internet.
Oh, so personal information is all over the internet.
Yeah.
That's crazy. All right, that's cool.
All right. Anything else at this time?
No.
All right. So ideally, you won't get any information from us because you'll be already out in the community after that hearing date. If not, if you are not released on July 30th, you know something's up, and we're going to bring you back for another hearing. Okay.
All right.
All right. So this does conclude the revocation hearing for Jean Lewis Finn, inmate number 401056056. All right. You have a great day. Good luck to you. Okay.
All right.
You're all set. Take care.